25 and section 26. So a confession that is made to the police officer, section 25, or the confession made in the custody of police officer, as per the Indian Evidence Act 1872, is not admissible. But in that confession, if it leads to a distinctively new fact, that portion that lead to the distinctively new fact, this new fact would be admissible. And then, like in our case, Pulkari Kotaya that we have discussed in this particular section 27, and in this case, Pulkari Kotaya versus Emperor, AIR 1947 Privy Council. The two confessions were mentioned in the case, and in those confessions, only that much of the portion that lead to the discovery of new fact was accepted as admissible. The confession that about 14 days ago I and Kotaya, and then how they killed that person, the weapon that used in that offense, the stick and the spear, and then that I hide them, and then if you allow me, I can show you. And then the police went to the place where the accused hide, and these weapons were discovered. So only that much, that the offense, the weapon of offense were lying at that place, and accused had the knowledge. Only that much of the portion. This particular fact that accused had the knowledge that where the weapon of offense were, lying, is admissible because it come under the section 27. Another confession in this particular case, that I stabbed Sivaya with spear, I hid the spear in the yard in my village, I will show you the place. Again, police went with the accused, and the spear was discovered. So again, the fact that accused know where the weapon of the offense was hiding. So this distinctively fact was made admissible as per section 27. Certain other things like the section 27, first it was challenged on article 14, and it was held that no, it is not violative of article 14. Then again it was challenged again in the Kathikalu Ogad case, and then certain other things that is required we had discussed. Now today we will start section 30 of the Indian Evidence Act. Section 28 and 29, we have already covered along with the section 24. Section 30 basically have the rule with respect to the confession made by a co-accused how it can be used against the other person, and in which cases it can be used. And then what is the evidentiary value What would be if it is a retracted confession, etc. So many issues also we will discuss that are related to the confession by the co-accused. So section 30 of the Indian Evidence Act basically contained the rules related to confession by the co-accused. Suppose there is a offense of murder, and in that offense of murder, two-person was suspected, and these two-person was then arrested, and it was alleged by the prosecution that these two-person have committed the murder. One of that accused has confessed that yes, I and my co-accused have committed this crime in this particular manner. Now, as the rule, it is a duty of the prosecution to prove the guilt of both the accused beyond reasonable doubt. And so when one of the accused is confessing, so that confession is can be used because that is allowed, that is a relevant fact. It would not be relevant if it is involuntarily, it is hit by section 24. It would not be admissible if it is hit by section 25 or section 26. Now the question is that suppose the confession made by one of the accused is voluntarily, so whether this confession can also be used against his co-accused to convict him. In simple sense, when more than one accused are on the trial of the same offense, it is the duty of the prosecution to establish the guilt of each accused. Each accused. Maybe sometimes the section 32 is applicable, sometimes the section 149 is applicable. But then also you have to show that they are in the, unlawful assembly or etc. So that rule lies in the section 34 of the IPC or section 149 may be applicable. But then also it is a heavy burden on the prosecution to prove. And in that case, whether the confession of the co-accused can also be irrelevant first thing, and how much evidentiary value it has, that also we have discussed. So this is the whole background while we discuss section 30. Now come to the section 30. Yes. Section 30, the consideration of proved confession affecting person making it and other jointly under trial for same offense. This is the marginal note. And now the section is, you have to read each and every word very carefully. When more persons, just give me 1 second, someone is calling me again and again. Okay. When more person than one, that means two or more than two, are being tried jointly for the same offense. So when two, more than one person means two or more than two person, they have to be under the joint trial. So in which cases the joint trial can happen. That also we have to discuss. And that is for the same offense. Same offense is calling, not the identical offense. And a confession, this is the prerequisite. Prerequisite that two or more than two person being tried jointly for the same offense. The confession made by one of such offense, one of such accused, one of such person, affecting himself and some other of such person is proved. So the confession must be there, made by one of the person who is tried, and that confession has to be proved. Then the court may take into consideration. See the language here, may take into the consideration. Only the discretion is there. Court may take into the consideration such confession as against such other person as well as the person who makes such confession. And here in the explanation, the offense as used in this section include the abatement or attempt to commit the offense. So abatement or attempt are also included. This is included for purpose of explaining the same offense. Okay. Now if you see the illustration, in the illustration itself you will understand. Before that, there are certain things that the section is an exception to the general rule. The general rule of the English common law. And what is that? If you remember, when we started the confession, that confession is only the evidence against the person who is making. The confession is the evidence against the confession and no other. But here, there is deviation from that rule. That confession is also being used to the another person. Because see, the accused is not the witness here. He is on the trial. And there would be no cross-examination. There was no oath administered. He is not a witness. ऐसा मत कहो कि सर वो कह रहा है तो वो भी सही कह रहा होगा, that is also a person. No. अगर कोई दूसरा विटनेस होगा उसको ओथ लेना पड़ता है, उसको क्रॉस एग्जामिनेशन होगा. But this person who is making, he was not speaking on the oath, he would not be cross examined. But then also it is used against. Okay, and so there is this deviation, but there is a reason. The reason is that when a person make a confession and that confession affect himself and the other, the fact of self implication take place as it were the sanction, as it on the sanction of oath, rather supposed to serve the some guarantee for the truth of the accusation against the other. When the person admit his guilt and expose himself to the pain and the penalty provided, and therefore that put his statement on the footing as the person speaking on the oath. In the simple word, when a person as a witness appear before the court and he speak after taking oath. फिल्म में सुना होगा ना कि गीता पे हाथ रख के कसम खाइए, जो भी कहोगे सच के सिवाय कुछ नहीं कहोगे. And if a person is giving the testimony and he lie, then there is perjury. Perjury. And the provisions also there in the IPC. When you speak, give the wrong affidavit, in any manner you speak lie, and that is established, that is perjury, punishable offense. So this oath that is administered, that is the guarantee that this person will speak the truth. And similarly, when a person is confessing, when a person is exposing himself to the pain and penalty, because when you are confessing, that means the result would be that you will be held guilty. And so this thing guarantees for his truth, that by his statement, he incriminating himself. In that sense, there is nothing, or you can say not a possibility that he will lie to the other person. Because the rule is that the person who's making, he's incriminating. Now, if a person is tried for offense of murder, there were the 5 persons. And one of the person, he said that just a man नहीं मारा, ये 4 लोगों ने मारा. This is not covered under the section 30, because this is not the confession. And so only the confession in which the person is incriminating himself, is taking the pain and the penalty, and that is the guarantee that put his statement on the same footing as the person who appears before the court and gives the statement, his testimony. And that's why this rule that the confession is used against the confessor or against the person who made it, it was deviated because there is another guarantee, there is another reason that such person would not lie. If he is, or if the section 30 allows only the statement in which a person is incriminating others, so that would be unjust. But this is the just section because there is some reasons about that. But in the value of evidence, it is considered as a weak type of the evidence. Section 30 is not talking about that is it weak evidence or it is hard evidence, or some other section are not present that talking about the evidentiary value. In many sections we have discussed that is the through the judgment of various courts or the commentaries of the scholars. Now, the English law and the Roman law are same, and hence this provision was also criticized by the courts and the commentators, that section 30 is characteristics as introducing rather dangerous element, as it's very exceptional and extraordinary provision. But then also, whether the commentator or scholar appreciate it or not, because they always say that it is very exceptional, it is an extraordinary, it is an very dangerous rule of evidence, etc. Still it exists, and it is the have the acceptable confession, so that confession can be proven. Now, the ingredients of the section 30, or you can say when we read section 30, we can divide it into the many elements. The first is that confession, that confession, when more person than one, that means 2 or more person are being tried jointly. So the first element is, it is five elements. First element is that the two or more person are on joint trial. Are on joint trial, or two or more person are tried jointly. Now, when the two or more person are tried jointly, for that you have to go to the CRPC. Chapter 17 of the Criminal Procedure Code 1973 talk about charges, and there are many provisions. As an advocate, you will visit these provisions frequently, and as a judge also, during the preparation also, as the judicial aspirant, you have to read these sections. Section 220 of the CRPC, trial for more than one offense. Section 219, three offenses of same kind within a year may be charged together. And Section 223, what person may be charged jointly. So basically, Section 223 is cover this first element, that more than one person or two or more than two person are being tried jointly. When two or more than two person are tried jointly, कब होती है दो या दो लोगों से ज्यादा की trial? When they are in the same offense, etc., etc. So Section 223 of the CRPC cover those situations. Section 219 and Section 220 that I have referred, these are also important, because another point on the second will be of the same offenses. Okay, so the trial for more than one offenses may be in the series. In the transaction there are many offenses. जो डाका डालने जा रहे थे, डाका डालने गए, वहां पे ताला भी तोड़ा, उसमें किसी को मार भी दिया, so many things. There is, in Section 220, there is an explanation that A rescue B, a person in lawful custody, and in so doing causes grievous hurt to C, a constable in whose custody B was, A may be charged with and convicted of offence under Section 225 and Section 333 of the Indian Penal Code. Section 223 talk about that what person may be tried jointly, and for our first element of the Section 30, we have to understand that the following person may be charged and tried jointly: the person accused of the same offense in course of the same transaction. Like the example of the murder that I was discussing, that two persons were arrested for causing the murder. So they are on the accused of the same offense. So they can be tried jointly. Okay. चार्जेस दोनों के अलग अलग बनेंगे, दोनों के चार्जेस की फॉर्मेट होगी, फिर उन दोनों को सुनाया जाएगा. That all the procedure that you have in this chapter 17 about that will be followed. But for the purpose whether these person will be put on as a same trial or will be on the different trial is Section 223 clarify. Section 30 of the Indian Evidence Act is talking about, or is, you can say, is applicable only when there is a joint trial, or when there are two or more than two persons on the joint trial. And for that, Section 223 is very important. When the person committing the same offense, person accused of offense and the person accused of abatement of or attempt to commit such offense. So maybe one person is like the murder and the another is abatement of murder. C, the person accused of more than one offense of the same kind and within the meaning of section 219 committed by them jointly within the period of 12 months. Okay. So it may be there is a thief, एक साल में उसने 3 चोरियां की. So under section 219, he can be tried for these 3 offenses in the same trial. एक बार जनवरी में चोरी की, फिर मार्च में की, फिर अप्रैल में की, और इन तीनों के एफआईआर भी थी, लास्ट में पकड़ा गया. लेकिन लास्ट वाली जब चोरी की तो उसमें दूसरा बंदा भी शामिल था. एंड ये लास्ट वाली चोरी में बिकॉज बोथ आर ऑन द committed same offense, so they are tried jointly, but because the first person is committed to prior offense, so section 219 will also come into picture. That's why I said in the section 219 and section 220. And so the person accused of more than one offense of the same kind within the meaning of section 219 committed by them jointly within the period of 12 months. So that would also be covered. Person accused of different offenses committing in course of same transaction. Maybe the offense committed are different, but they are on the same transaction. So that would also be put them into the same trial. So these are the some clauses you have to read in section 223. In that situation, a person is put in the same trial. 2 or more person put in the same trial. So that type of the situation should be there. This is the first element, that more than one person are being tried jointly. The second one is that the joint trial is permissible by the law. If they are tried jointly and you are able to prove that this joint trial is not permitted because it does not cover under the section 223. So in that situation, section 30 would not be applicable, because section 30 would applicable when there is a joint trial. So that the second thing. The third is that the joint trial is for the same offense, and in the explanation it was said that the same offense also include abatement or uska attempt bhi. So the joint trial is for the same offense, for the abatement or attempt. And the fourth one is that there must be confession. There must be confession, or you can say there must be proved confession, duly proved confession. So there must be duly proved confession. That means that confession is not vitiated by section 24, 25 or 26. That means it is that confession that is not hit by section 24. It is not made before the police officer. It is not made in the custody of the police officer. And then comes to the fifth, that the confession of the guilt must implicate the maker substantially to the extent as the other accused. If the accused person is saying and just want to exculpate himself and want to throw the guilt to the other person, so that would not be applicable. So these 5 things must be there. Then that confession by one of the person may be used by the court against the other person who are on the joint trial. Now, for the same offense means that offenses of the similar kind and not that of the identical. Section 223 talk about when the persons are on the joint trial, but in that joint trial also, section 30 cover only those that are for the same offenses. For the same offenses. So the joint trial must be for the same offenses or for its abatement or its attempt. These three things. The joint trial means offenses of the similar kind. But that similar kind does not mean that one accused is being tried for the theft and the another is for receiving the stolen property. So this is maybe something in the one transaction, and the joint trial is permissible, but the confession of one is not admissible against the another, where the two accused were tried jointly for the same kind of the offense under section 411 of Indian Criminal Code, but the property in respect of which they were charged was different in the case of each accused. It was held that the confession of one could not be taken into the consideration against the another. The judicial opinion differ as to the word offense include the offenses and whether the confession must implicate the maker in all the offenses for which he and other accused are being joint trial. So maybe the two persons are on the same type of the offense like the section 411, but one related to another property and the second related to some other property. In that situation also, it would not be applicable. And so in that, keeping all these in example, the same offense means that that offense of the similar section, and it has to be related to the same activity, or whatever I have said in the earlier, like you can say that identical elements must be there. Like if it is the offense related to the murder, so it has to be murder with respect to the same person. So that type of the offenses has to be. Okay. Now there are, if you remember, there are four type of the trials. One is first is the that is biggest trial, session trial, then session trial. Then the second one is trial by the magistrate in warrant cases. The third one is the trial by the magistrate in summon cases. And fourth is the summary trial. And in these trials, there is one stage where judge asks that to the accused whether he plead guilty or not. And in that situation, when accused plead guilty, how that pleading the guilty has to be seen in the connection with the section 30. So there, that in the session trial, if accused plea the guilty and the plea of the guilty is accepted, and when the plea of the guilty accepted, that means there would not be trial. So no joint trial, and when there is no joint trial, then there is inadmissibility of the confession. Am I getting? Suppose there are four accused, and they are accused in the such offenses where there is the session trial, like the murder, etc. In that, if some of the accused plead guilty, when they plead guilty, the plea of the accused is recorded at very outset, and the trial start after the plea is recorded. If the accused plead guilty and is convicted on that plea, the trial against him come to the end. And therefore, where one of the accused person committed to the court of session, some plead guilty, and this plea being accepted, they were convicted and they were no longer be treated as the joint trial who have not pleaded the guilty. And if the person who have not committed the guilty against whom the trial will start, the confession made by the accused who plead guilty would not be admissible because they are not on the trial. Okay? Now come to the second situation. When the plea of guilty is not accepted by the court, and court say that let be the trial. In that case, these person, though they made the plea that they are guilty, but the court decided to for the trial. And in that situation, when they are on the trial, the confession made by such person who plead guilty, because they are on the trial, their confession may be used against the other. So that is the difference. In the one situation, the accused who made the confession plead guilty and court accepted. And so he is convicted, he would not be on the trial. And for the rest person, the trial will start. So the confession by the person who plead guilty would not be applicable against the other because it does not meet one of the ingredient of the section 30. If in the joint trial or summon cases plead guilty as the session trial, so in the summary cases, summon cases, the plea of accused is recorded at the outset of the trial, and therefore plea of guilty in the summon cases has the same effect as in the question of joint trial in the session cases. So the same effect it would have. Now come to the next element, that confession must affect himself and the other person. And here there are two situations. In one situation, the accused is saying that I and my co-accused committed this. And that means he is not exculpating himself. He is admitting his guilt and along with his co-accused. So, in that case, section 30 will apply because that is the requirement of the section 30. But some explanatory statement, exculpatory statement in which the person who is confessing want to shift the guilt from himself to his co-accused. In that case, his confession cannot be used because section 30 would not be applicable. So the exculpatory or explanatory statement are not admissible under this section as they cannot be said to affect the maker. If on reading the confession as a whole, it appears that maker was trying to throw the main blame on his companion and to make out that he himself was unwilling spectator of the crime, the confession cannot at all be taken into the consideration against the co-accused. And thus the confession to be admissible under section 30, it must not exculpatory but also inculpate the maker himself substantially to the same extent as the other. So this is next element of the section 30. Now it is not saying that section 30, in section 30, that who will record the confession, at what stage it was made, whether it is judicial confession or extrajudicial confession. Section 30 basically covering all the situations. Applicability of this section 30 at the trial as well as those made before the trial. The section is not applicable, not limited in its applicable to the confession made before the trial or the inquiry, the confession made during the course of trial and the are equally admissible. There is nothing in section 30 to restrict the confession to one recorded before the magistrate, as I said, and so it would also be cover the extrajudicial confession also. So these were the element, the reason for the making the confession by one of the accused admissible against the another accused. There is always the fear that the person who is in the trial, he would not be cross-examined. His statement was not on the oath. And so, whether he is speaking truth or lie, there is always a question. There is no fear of perjury also, because he is not giving the testimony. उसमें कोई सजा नहीं हो सकती कि आपने झूठ बोला. And so many scholar, commentator, they criticize that this provision is the deviation from the English common law, that the confession is used against the confessor only. And the reason for making such confession applicable against the co-accused is that the person who is taking the pain and the penalty for himself, his position is like the person who is deposing before the court after taking the oath. And so such person would not lie. Then we discuss that elements of the section 20, section 30, and what is the scope of those also we have discussed. Now come to the next thing, and that is the evidentiary value of the section 30. On the evidentiary value of the section 30, you will not find a single word in section 30 or in the other sections. But try to understand that the position of this type of the confession. As I said, that the person who made the confession, his statement, he made that statement without any administering the oath. he would not be cross-examined. And in the evidence law, the cross-examination is known as the procedure where the veracity of the witness is checked. And so there is no method to check the veracity because there would not be cross-examination. Second thing, that he did not made on the oath, so that is also important. The person who made the statement, he did not made before the court on the oath. There would be no cross-examination, and so such statement must not be relied heavily. This confession have very low evidentiary value. This is a very weak type of the evidence. Why? Because these statements were not divulged while administering the oath, and there is no cross-examination because this is not that type of the testimony. And someone say that even that it is weaker than even the approval. It is weaker than even the approver. Who is the approver? The person who was participated in the crime, but because the police did not have the evidences, so this person was made approver. And he is giving the evidences as a testimony. Why the police made such person approver? Because if the police would put that person also on the trial, in the charge sheet, if that person would also be named, then he would be accused, and accused की गवाही तो हो नहीं सकती उसके खिलाफ. Okay, so accused testimony cannot be used for the prosecution. And so this person was exempted. Now the question is that how we say that the evidentiary value of such confession under section 30 is even weaker than approval, because after approval उसको ओथ लेनी होगी, उसका क्रॉस एग्जामिनेशन होगा, तो सच्चाई सामने आ जाएगी. बट in that situation it is not possible that the person who made the confession is on the trial. It's in the same trial. And so it is even known as the confession by the co-accused is even the weaker evidence than the testimony of the approver. Section 114 explanation B and section 133 that both we will discuss, that talk about the evidentiary value of the approver, because he is exempted by the police, and so in that jail sometime he stayed in the fantastic manner all the story, और भी बड़ा चढ़ा के वो बताता है. But then also there is the method to check his veracity, but that is not applicable because the person who made the confession is also on the trial. And so that in that sense we can say that it is very weak type of the evidence. There is one case, very famous case by the Supreme Court, Kashmira Singh versus State of Madhya Pradesh. You can write the name also, Kashmira Singh versus State of Madhya Pradesh. And in this case, the Supreme Court, Kashmira Singh versus State of Madhya Pradesh, 1952 SCJ 2012. The Supreme Court of India has held that confession of co-accused is not evidence within the meaning of the term as defined under Section 3 of the Evidence Act. It is not required to be recorded on the oath, and it cannot be tested by the cross examination. It is evidence of very weak type, and it is much weaker than the evidence of an approver or an accomplice. It is settled principle of law that the confession of co-accused person cannot be treated as a substantive evidence and can be pressed into service only when the court is inclined to accept other evidence as feel necessity of seeking for an assurance on spot of the conclusion deducible thereof. See, the evidences, certain evidences are substantive evidence, that means that can be the sole basis of the conviction, and the other evidences are just the sportive evidences, corroborative evidences. So this is very weak and it is not an substantive evidence because it does not fall under the definition of Section 3 in the definition of evidence. And so it is very weak. It is only the sportive when the judge feel, when it is, at the reach, at the conclusion, that type, that can also be taken into consideration. But because it is admissible that it can be used under Section 30, so that is the effect, but it is not the substantive nature of the evidence. The another phrase that we saw in the Section 30, that court may use into the consideration such confession. So what is the significance? What is the implication of that? The expression that court may use into the consideration such confession, it signifies such confession by maker as against the co-accused himself should be treated as a piece of corroborative evidence. भाई हमने कहा ये वीक टाइप का एविडेंस है, कश्मीरा सिंह ने कहा कि एविडेंस ही नहीं है बिकॉज सेक्शन 3 के अंडर कवर नहीं होता ये, उसकी डेफिनेशन में ओथ पे भी नहीं होता है, ना इसको क्रॉस एग्जामिनेशन कर सकते, एंड सो इट इज वीक. So what does it mean that court may take into the consideration? That mean when the legislature is allowing, so this phrase means that it is not a significant, it is not an substantive evidence but a corroborative evidence. It cannot be the sole basis of the conviction. Okay. In absence of any substantive evidence, no judgment of conviction can be recorded only on basis of confession of a co-accused, be it extrajudicial confession or judicial confession, and list of all on the basis of retracted confession. So it cannot be the basis of the sole basis of the conviction. Corroboration is always, required for such confession, or it can be corroborative of other evidences. So other evidences are available, so then this confession can also be helpful for convicting the accused. The court may take into consideration. Now the question is, when we are saying that it is not a substantive evidence, it's like the corroborative evidence, or this evidence can be used, but there must be the corroboration by some independent evidences. The next question comes in the mind, that how much of the corroboration is required? As we have already discussed that why the corroboration is necessary, because a confession of co-accused stand on the lower footing than the evidence of accomplice, as the confession prisoner neither speak under the sanction of oath nor his statement is tested by the cross examination. The That's the reason of the, you know that it such confession under section 30 require corroboration. But at what extent it required the corroboration? Apart from the confession from the co-accused, the foundation of the case against the co-accused is other corroborative evidences, the two general principles bearing upon the nature. The first is that the corroboration must be on the material particular. The corroborating evidence must such as implicate the non-confessing prisoner, which confirm the some material particular, not only the statement of the confession. So there must be some material particular in which, because the burden is on the prosecution, and prosecution cannot say that only because there is the confession by the co-accused he is relieved by his burden. Another is there is inherent danger, and some scholar even say that it is very dangerous provision. And so, because it is a weak type, because the person who is speaking was not speaking while administering the oath, and there is no scope of the cross examination, and so some on some material points there must be independent evidences. Secondly, the corroboration must be by independent evidence and not by the testimony of the accomplice nor the confession of another co-accused. सो इन कोराबरेशन में अकोम्प्लिस की और एविडेंसेस है, तो आप कह दो कि एक तो इसका को अक्यूज की confession, second accomplice, so that is also not applicable. Such confession carries an inferior evidentiary value. Tainted evidence is not made better by being doubted in an quantity. When there are two set of evidence each requiring corroboration, one cannot be used to corroborate other. सो द accomplice का जो एविडेंसेस है वो खुद ही corroboration की रिक्वायर्ड है, और यहाँ पे confession by co-accused वो भी corroboration की रिक्वायर्ड है. सो when the two pieces of evidence require the corroboration, they cannot corroborate each other. Now the next point is, you have to finish it very quickly, that suppose the confession made by the co-accused is there, and then he retracted from his confession. As we discussed the confession, there was a concept of retracted confession and the evidentiary value of retracted confession. Just give me 1 minute. Yes. Sorry. So under section 30, suppose the same person who made the confession, he retracted later on, how much evidentiary value of this retracted confession with respect to some other person, where the section 30 allow that it can be used against the other accused. For that, the retracted confession of co-accused cannot be relied upon for the purpose of finding corroboration for the retracted confession of an accused. There is this case of Babuni Sahu versus King. (49). This is in the bracket 76 IA 147. In Babuni Sahu versus King, the court said that the court may take the confession into consideration and thereby no doubt makes it evidence on which the court may act. But the section does not say that the confession is to amount to the proof. The section is saying that the confession is the relevant, it is admissible, it is used. It is not saying that confession may amount to the proof or consideration. The confession, when is making the admissible, it is such that it is on the same footing as it is the proof. And clearly there must be other evidence that confession is only one element into the consideration of all the fact proved in the cases. It can be put into the scale and weighed with the other evidences. And so the confession by the co-accused cannot be relied for the purpose of finding corroboration for the retracted confession of the accused. Now there is another thing, that suppose there is a confession by one of the accused in the joint trial, and this confession, he said that this confession, he argued that this confession was during the custody of the police officer. That means the accused want to take the benefit of section 27. Okay. Again, I am saying, suppose there are the three accused in the offense of the rape, and the police arrested these three accused, transported these three accused to the hospital, and there the examination was conducted. One of the accused broke down and he made the confession before the police officer while the police personnel was standing outside the room where the examination was conducted. In the trial, this confession was used, and the accused want to take the benefit of section 26, that this was confession while the accused was in the police custody. And the prosecution said that, okay, that this confession was in the police custody, but so much part of the confession that after the rape, we hide our clothes in particular place. If you come with me, I can show you. And the police searched there and the clothes were seized, where there are the blood stain, etc. Like in Agnu Nakesha, blood stain chadar. And so this fact, this discovery of this fact that the accused know where the clothes that was, weared by the accused when the offense was committed, was in that his knowledge. So that means the prosecution want to take the benefit of section 27 to making certain fact that is discovered. And for that purpose, that this section, this fact that is discovered would also be used against the co-accused also. So that is the relation between section 27 and 30. The confession, if made by the magistrate, it has to be assured. Magistrate has to assure that it is, voluntarily, without any thing. And so the only nature of that, it must not be involuntarily, it must not be by force or by violence. Supreme Court has observed that it is well settled that confession made by a person against the co-accused cannot be used as substantive evidence. It can only be used as a corroborative piece. The Supreme Court held that in absence of any reliable substantive evidence, the confessional statement cannot be used for purpose as against the co-accused. And in that also, all the rule that we have discussed with respect to the confession, that confession must not be inducement, threat, or promise by the person who is the authority in reference to the charge, or taking a benefit or avoiding the evil nature. That means section 27, section 25, section 26. If these are applicable, then the confession would not be even used against the confessor. So it would not be used against the co-accused also. So that limited scope section 30 has. And so with that section 30 we have discussed. The cases on the section 30 we will take in the next class. Before that, I will start another provision here, that is section 32. Section 32 is very lengthy provision and it covers certain situations. You have to understand the section 37, section 32, sorry, not 37. It's really very interesting provision. But we are not here to discuss whole section 37, 32, but only one clause of the section 32. Section 32 clause 1. Section 32 contain 8 clauses. Section 32 clause 1 we have to discuss, that is in our syllabus, and that is known as dying declaration. Section 32 clause 1, dying declaration, in short form DD. Certainly one question is asked from dying declaration. It is so much of the important. There are many issues related to the dying declaration, its evidentiary value, its purpose, etc. So many things are there. Section 32 basically making certain statement made by the person as relevant. इसमें कहो इसमें नया क्या है? We have discussed section 162 of the CRPC, that the statement made by the police officer for his purpose, for investigating purpose, as per the section 161, he can reduce into the writing, but that has not to be signed by the maker of the statement, and it will not have any evidentiary value. उसका मतलब क्या हुआ कि जो भी विटनेसेस हैं वो कोर्ट के बिफोर आएंगे एंड दे विल डिपोज बिफोर द कोर्ट. सिविल केसेस हो, क्रिमिनल केसेस हो, सबको कोर्ट के बिफोर आना पड़ेगा, कोर्ट में डिपोज करना होगा आफ्टर टेकिंग ओथ, क्रॉस एग्जामिनेशन होगा ताकि उनकी वेरासिटी चेक की जाए. आपने देखा होगा बहुत सी मूवीज में क्रॉस एग्जामिनेशन में लड़खड़ा जाते हैं. But section 32 is saying that certain statements that are made outside the court, कोर्ट में नहीं डिपोज कर रहे हैं, पहले बनाई हुई स्टेटमेंट, also be relevant. That means it is an exception. बट उसका पर्पस क्या है एक्सेप्शन का, उसके पीछे लॉजिक क्या है? So section 32 covers the statement made by 4 persons. First is the person who is no more, who has died. So the person who has died. अब ऐसे आदमी की स्टेटमेंट, ऐसे आदमी को क्या आप लोग उसमें कोर्ट में लाओगे, किसकी शपथ दिलाओगे, कि क्या क्रॉस एग्जामिनेशन करोगे, बिकॉज पर्सन इज नॉट अवेलेबल. Suppose an offense was committed and the person was ब्लीडिंग, खून निकल रहा पूरा, हॉस्पिटल ले जाया गया और उसने बताया कि भाई शेरशाह ने उसे मार दिया. पर्सन वाज अबाउट टू डाई एंड सेड शेरशाह ने उसे मार दिया. अब ये आदमी जब उसके बाद में मर जाता है, ट्रायल में तो ये मिलेगा नहीं. अब ऐसे आदमी के स्टेटमेंट को अगर हम रिलेवेंट नहीं कहेंगे या उसे एप्लीकेबल नहीं कहेंगे, सो दैट वुड बी अगेन वुड बी अनजस्ट, दैट वुड नॉट बी इन लाइन ऑफ प्रोवाइडिंग जस्टिस. नहीं, उसको जस्टिस लेना है तो कोर्ट में आना पड़ेगा, क्रॉस एग्जामिनेशन होगा. नहीं. सो द पर्सन हु इज डेड, second, who cannot be found. अब फकीर हो गया, पता नहीं कहाँ हिमालय की कंदराओं में छुपा हुआ है, उसको कैसे करोगे? But if his statement is also of such nature, it's not that only because I said that he is no more उसकी स्टेटमेंट हो जाएगी. वो प्रोविजंस में, क्लॉजेज में है, वो भी किस सेंस में और कितना उनका वो रिलेवेंट होती है. When this provision is making certain fact is relevant, that means that it does not amount to proof. उसका मतलब नहीं कि उसी पे उसको सजा हो जाएगी, उसी पे हो जाएगी. जैसे हमने कहा कन्फेशन, तो उसका वैल्यू है, इसका मतलब नहीं कन्फेशन हो गया तो पूरी तरह से वही हो जाएगा. उसकी एविडेंशियरी वैल्यू हम वो भी देखते हैं. सो व्हेन ए पर्टिकुलर फैक्ट इज ट्रीटेड एज द एडमिसिबल, दैट डज नॉट मीन कि वो सफिशिएंट है, वो प्रूफ के बराबर है, उससे सजा हो जाएगा, ऐसा कुछ नहीं है. ट्रायल में वो का आपने देखा होगा कई बार हो जाती है, वो भी कोई ऐसा घबराने की बात नहीं. सो द पर्सन, जब उसने स्टेटमेंट हुआ उसके बाद में उसका तो बड़ा मोह भंग हो गया, वो हिमालय की कंदराओं में चला गया. सच पर्सन विल नॉट आल्सो बी एक्सेस्ड. एंड द थर्ड वन इज द पर्सन इज इनकैपेबल ऑफ गिविंग एविडेंस. अब वो इतना बूढ़ा हो गया, ना उसको समझ सकता, ना वो बोल सकता, मरा नहीं लेकिन वो मरे बराबर है. एंड द फोर्थ वन इज पर्सन whose attendance cannot be procured without any amount of delay or expense under the circumstance of the case appear to the court as reasonable. छोटा सा एक थेफ्ट का केस है और बंदा वहाँ नॉर्थ कोरिया में, अब वहाँ से कौन लेके आए उसे विदाउट एनी डिले और रीजनेबल एक्सपेंसेस, कोर्ट को लगता है वो नहीं ला सकते. सो दीज फोर पर्सन्स इज सेक्शन 32 covers. That means section 32 basically covers the statement of those persons who are not available to the court for deposing before the court for the cross examination or administering the oath. So in that situation, as a public policy, the certain statement were made relevant by the section 32. So this is the background. Now come to the section 32. If you have the case material, the direct, you also read with me. But we have not to discuss all the clauses. There are 8 clauses. The first clause is section 32, that when it relate to cause of death. Second is or is made to the course of business. Third is against the interest of maker. Fourth is gives opinion as to the public right or the custom or matter of general interest. Fifth is relate to existence of relationship. Sixth is made in will, deed relating to family affairs. Seventh is or in document relating to transaction mentioned in section 13 clause A. Eighth is or is made in several person express feeling relevant to the matter in the question. And in the explanation also you will find that it is really very interesting section. So all these things would be very applicable. Like come to the second clause, that made in the course of business. And made in the course of the business, there is, you know, very uh, lively illustration. Illustration B. The question is as to the date of A's birth. क्वेश्चन है कि ए का जन्म की कौन सी तारीख है, उस पर जैसे डिस्प्यूट है, जैसे पहले हमारे जनरल आर्मी के जो जनरल थे वीपी सिंह, उनकी उस पर भी हुआ था। वीपी सिंह था, क्या नाम था बता दें। द एंट्री इन द डायरी ऑफ द डिसीज सर्जन, जिस सर्जन ने उसकी उसकी मम्मी की डिलीवरी के समय उसको अटेंड किया था, उसकी मदर की डिलीवरी के समय, उस सर्जन ने अपनी डायरी में नोट किया था, जो वो रेगुलरली केप्ट करता था जब भी डिलीवरी करवाता था। An entry in diary of the deceased surgeon regularly kept in the course of business, stating that on the given death he attended A's mother and delivered her of a son. This is a relevant fact. अब यहाँ पे अगर ये सर्जन जिंदा होता तो हो सकता है उसे कोर्ट में बुला लेते, उससे पूछते, हाँ जी आपने इनकी माँ की डिलीवरी के समय आपने इनको अटेंड किया था, हाँ अटेंड किया था, ये हुआ था, किस समय हुआ था, क्या डेट हुआ था। But because he is not applicable, he is not there, so that the entry in the diary, okay, so that this statement would also be relevant because it is kept in the course of the business. I'm saying that it is relevant. अब ना तो ये statement उसके oath के ऊपर administer, ना इसमें cross examination की possibility, क्योंकि आदमी नहीं है। बट रिलीवेंट का मतलब ये नहीं होता कि प्रूफ हो गया, बहुत सब्सटेंशियल एविडेंस हो गया। ये एक रिलीवेंट फैक्ट है, कितना एविडेंशियरी वैल्यू होगा ये हमें डिस्कस करना है, इस पे नहीं बताता, बस केवल रिलीवेंसी बताता है। ओके, सो दैट थिंग। सो सिमिलरली यू नो अदर clauses also you have to read, because we have limited time, so we have to discuss whatever is in our syllabus, and that is only section 32 clause 1. Okay, section 32, that statement written or verbal statement, whether it is in the verbal form or the written statement of relevant fact made by a person who is dead or who cannot be found or who has become incapable of giving evidence or whose attendance cannot be procured without an amount of delay or expense which under the circumstance of the case appears to the court as reasonable. So whether the attendance of the person is cannot be procured with delay or expenses, this is also again the court has to decide. If the court decide that no, you have to produce that witness, so in that situation his statement, earlier statement, verbal or documentary, would not be relevant. Are themselves relevant fact in the following. So in that situation, the statement of the person with respect to the relevant fact, like the example we have already discussed, the question was age, birth, is date of birth. And in that question, when A was born, it is a relevant fact. So with this fact, the statement of the person that he was born on that person, when this person cannot be, when this person is dead or is, is not capable to give the evidence or cannot be found, etc., etc., in that situation, this statement with respect to this relevant fact itself became the relevant clause. First, when it relate to cause of death, when the statement is made by a person as to the cause of his death or as to any of the circumstances of the transaction which result into the death, in cases in which the cause of the person death come into the question, such statements are relevant whether the person who made them was or was not at the time when they are made under the expectation of death, and whatever may be the nature of proceeding in which the cause of his death come into the question. So basically it's saying that when a statement is made and this statement is made as to the cause of his death, so in the first thing is cause of his death, so we can cover किसी को चोट लगी, उसको हॉस्पिटल ले जाया जा रहा है और उसने बताया कि भाई मेरे को फलाना आदमी ने चोट दी, और उसके बाद में सब्सिक्वेंटली ही डाइड, ही इज नॉट एबल टू गिव द एविडेंस. सो ये स्टेटमेंट दैट ऑफ हिज कॉज ऑफ डेथ, ये रिलेवेंट हो जाएगी अंडर सेक्शन 32 क्लोज 1, और इसको डाइंग डिक्लेरेशन बोलते हैं कि मरने से पहले उसने डिक्लेयर किया। और as to the any of the circumstances of the transaction which resulted into death, आपने कह के गया कि मैं अपने दोस्त राहुल के घर जा रहा हूं, और देन योर डेड बॉडी वाज फाउंड। सो दिस स्टेटमेंट यू हैव सेड दिस बिकेम डाइंग डिक्लेरेशन। यहाँ पे आपने नहीं बताया कि मेरा डेथ का कोज क्या हुआ था, लेकिन दिस इज ए स्टेटमेंट इन द सर्कमस्टांसेस of the transaction that result into your death. And this statement would be applicable in civil cases and the criminal cases, and on this point our law is different with the English law. And then it is also said that maybe when you made the statement you were not expecting that you will die. You are not under the expectation that you will die. So when you said that I am going to Rahul will and we will play, we will watch the movie, you are not in any expectation, then also this statement would be relevant under section 32 clause 1, because it covers under the second part that as to any of the circumstance of the transaction which resulted into his death. So again I am reading, when the statement is made by a person as to the cause of death or as to the any of the circumstances of the transaction which resulted in his death, in the cases in which cause of the person death come into the question, in any cause, in the case where the cause of the death is come into the question, maybe it is civil case or the criminal case, and in the latter para it is again explained. So the first para in itself is sufficient. The second para in the section 32 clause 1 is just explanatory. The first para is saying that as to the statement as to the cause of death, or the statement as to the any of the transaction, any of the circumstance of the transaction which resulted into that. That means when you made the statement, you were not expected that you will die only. And in the latter part, it is explained that also that we have said that such statements are relevant whether the person made was or was not at the time when he made under the expectation of death, or whatever he made is may the nature of the proceeding in which his cause of death will come in the question. That means it may be in the civil cases or in the criminal cases. And then the illustration that is relevant to this section 32 clause 1. The question is whether A was murdered by B. A dies of injury received in a transaction in course of which he was ravished. The question is whether she was ravished by B, or the question is whether A was killed by B. Under such circumstances, that a suit would lie against B as A's widow. Statement made by A as to the cause of his death, of his or her death, referring respectively to the murder, the rape, in the first situation the murder, the second situation the rape, and third situation the actionable wrong under consideration, are relevant fact. So three situations were there. First, that A murdered B. So B ki statement, A was murdered by B. So A ki statement. In second situation में A dies of injury received in a transaction in course of which she was ravished. सी का रेप हुआ और उसको इंजरी कोज हुई और उन इंजरी से वो मर गई. Like in Delhi, the rape of that the girl Nirbhaya. So the A statement. And the third situation, the question whether A was killed by B under a circumstance that a suit would lie against B by A's widow. In तीनों circumstances में A की statement would be relevant. And reason is because he is not applicable. He is not alive, he is not to be available for giving the evidence before the court. Now, this is the provision. The reason behind this principle is basically there are two reasons to making such statement or making the dying declaration as a relevant fact. The legislature has made the dying declaration as a relevant fact on two grounds, or you can say there are two justification. As such, it is a hearsay evidence. If the cardinal principle is a of the evidence law says that if there is an evidence of something that can be seen, so the person who saw it, if the evidence of something that is perceptible by senses, so the any person who's perceived by his senses, or if anything that subject to hear, so any person who heard it. Now the question is whether A murdered B, and before dying B said that A murdered me because A saw that how B saw that how A stabbed. क्वेश्चन है कि ए ने बी को मर्डर किया कि नहीं, बी ने देखा कि कैसे ए आया और कैसे उसको स्टैब किया. So this stabbing, all these things is subject to be seen, and the evidence can be given only by the person who saw it. कोई वहां पे आई विटनेस हो या विक्टिम अपने आप में जिसने देखा है. Now victim said that A ने मुझे ऐसे ऐसे स्टैब किया, मारा, and he said to the doctor who attended him. Now the doctor has not seen that A stabbed B. And so in that sense, when doctor, you know, deposed before the court that before me, B said this, and this was his dying declaration. So this statement, B statement is relevant, but whatever B said, it is, deposed before the court by the doctor. And so this is an hearsay evidence in that sense. When that person be as a victim alive, and when he tell the whole story before the court, that would be a direct evidence. But here, whatever he has said, doctor ही तो बताएगा. So in that sense, it is hearsay evidence. Section 32 is an exception to this general rule against the hearsay. And there are two reasons, as I said. First is that the person, victim, would not be available for deposing before the court. अब वो तो आ ही नहीं सकता. And the second is that a dying person would not lie. जो मरने जा रहा है, he would not lie. But this principle would also not applicable in all situations because section 32 scope is very wide. This section is not like the English provision. So as such, that the person who is about to die would not lie because no one want to meet his creator with lie mouth. मतलब अब क्या झूठ बोलेगा? Because all whatever the things are there are, false now. The principle underlying the admissibility of dying declaration is reflected in a well-known legal maxim, Nemo mortuus presumptus mentor. The man will not meet his maker with a lie mouth. A dying man is face to face with the maker without motive for telling a lie. A man on the death ward will not tell a lie. The court said in one of the case that when a person is facing imminent death, when even the shadow of continuing in his this world is practically over, every motive of falsehood is vanished, and the mind is changed with most powerful ethical and moral consideration of speak truth and truth only. And so, when the person is about to die, he has to meet his creator. The all worldly things would become falsehood. And so, when he is speaking, his statement is at the same footing as the person who is speaking before the court while taking the oath. And so, in that sense, his statement has to be regarded in that sense. But then also there is one problem that the provision that our section 32, it's very wide and its scope is very wide. It covered in even the such a situation when the person is not in expectation of the death. And so there is another justification, and that is the person, because he would not be available to the court. And so there is no scope that the person who already died would come before the court. There would be the administering of the oath and the cross examination. वो हो ही नहीं सकता. And so like to make that statement is also relevant, but that does not mean that it is like the proof. It is only a relevant fact. How much evidentiary value it has, in what situation it would have, how the dying declaration is recorded, there is many things we have to discuss. The ground of admission of dying declaration are the necessity for victim being generally only the principal eyewitness to the crime. The exclusion of his statement might defeat the end of justice. And secondly, the sense of impending death, which create a sanction equal to the obligation of oath. At the point of death, and when every hope of its word has gone, when every motive is falsehood and silence, the mind is induced by most powerful consideration to speak truth. A situation so solemn and so awful is considered by law as creating the obligation equal to that which is improper and positive oath administered by the court of justice. And so, with those situations, this is, uh, treated as the uh, relevant fact. Now, there is a difference between English law and Indian law with respect to dying declaration. In English law, the dying declaration is applicable only in the criminal cases, and that is only for homicide and the manslaughter. That means you can say our culpable homicide and the murder cases. But here, the dying declaration is applicable in civil and criminal cases. And secondly, the English law, the declaration should have been made under the sense of impending death, where under the Indian law is not necessary. That means the person has to be expecting the death. But here, that situation is also not there. We cover even those statements where the person was not expecting the death. And so only to say, in many books you will find only that the person who is about to die, who is on the deathbed, etc., would not lie. That is not the proper justification, because section 32 is much wider. It covers some other statement also. The statement by the person as to the transaction, the circumstances of the transaction that lead to the death. And so in that situation, as I gave that I going to my friend Rahul, and then the person was found as dead. So this last statement would also be relevant as the dying declaration. He was not, when about he was going to play with his friend Rahul, he was not expecting death and other thing. And so only we say that is not applicable. And so there is another justification that the one is that the accused is the one eyewitness, and the second is he would not be applicable, he would not be available for deposing before the court. So there is no administration of justice, administrative oath and cross examination is possible. And so, to for the end of the justice, it is made such statement as a relevant fact. So, with this, today lecture is over because we are exhausted all the time. Now, in the next class, we will discuss the form of the dying declaration, how it is recorded. Generally, it is recorded in question answer form, and then the evidentiary value also we will discuss, and then there are some possibility where dying declaration is incomplete. So these certain things we will discuss. Then we will discuss whether the dying declaration can be the sole basis of conviction or not, etc. These mean evidentiary value and cases that we have on the dying declaration in section 30 also, that if any case is available, that also we will discuss. So with this, today class is over. Now you have to discuss, and you have to read section 30 and section 32 thoroughly, and the cases, the next cases, 2 3 cases you read, maybe in the next class we will discuss these also. So with this, today class is over. Now I'm giving you 1 minute. If you have any question, you can ask me.